Hello, this is Matt on the Moon Lambo channel. As I reported the other day, as did many others within the XRP community, there's been yet another delay within the SEC versus Ripple lawsuit. And the true cost of delay is staggering. It's absolutely staggering. And attorney John Deaton, he shared some thoughts on Twitter, and the first sentence reads as follows. The worst thread I've ever written. I'm sorry. So that certainly caught my attention. Now, I will say this, and this is my humble opinion. It's actually a great thread. It's just John Deaton doing what he does. He does a great job of articulating his position, his personal opinion as it applies to this SEC versus Ripple case. So when he says worst thread ever, yeah, there's some potentially bad sounding news in here, but he's keeping it real. Like, who else is like taking real, observable, like real world action to try and fix the train wreck that the SEC has created? Like, who's doing that to a greater degree than John Deaton out of anybody else that's in the XRP community, right? He's at the top, right? He's pretty damn well at the top, obviously. And also, by the way, I'll mention this. Attorney Deaton points out that the SEC has argued that it does not choose what is or is not a security, only that it can bring charges that something was sold as a security. And then it's up to the courts to decide if that is accurate or not, which is an interesting argument. So I'll get into the specifics and make sure you got full context and you get the full wording from attorney John Deaton. But that's a big part of what he was talking about here. So I'll tell you, it's just, to me, it's endlessly insane. The more we learn, the more developments unfold. All the twists and turns that we've been along on this case. It's mind-blowing to me that this is real life. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, before I get into that main thread, I did want to share something else from John Deaton, which is brief but very important, and I thought it would make sense to throw this towards the front part of the video, especially since it's quick anyway, but it's on topic, though. So check out what John Deaton wrote. The SEC's motion for reconsideration has caused enormous confusion. The SEC is still claiming the Hinman speech was his personal opinion. That hasn't changed. The SEC is not asking her to reconsider her finding that fact is settled. So pause. Just make sure everybody's caught up to speed. There was a ruling within the last few days, and the judge, Judge Netburn, did find that the Bill Hinman Ethereum free pass speech was just his personal opinion. As a result, the SEC, their arguments that there's privilege, and as a result, the Bill Hinman speech shouldn't have gotten out. The judge looked at that and said, no, it's just a personal opinion. There's no privilege there. And so what John Deaton here is pointing out, that the SEC is still claiming that the Hinman speech was his personal opinion. So that part hasn't changed. The SEC is not asking her to reconsider her finding that the fact is settled. The SEC is arguing that although it was Hinman's personal opinion, he received input or guidance from other SEC staff, and because of that, it is all protected by DPP. The SEC argues the law protects this internal communication even though it didn't result in an SEC decision. Exactly, so hitting the nail on the head, of course. And it's still repulsive to me because I don't believe that the SEC believes what it's arguing. It just doesn't want these documents out. It makes me wonder what damning evidence there might be inside of these documents. It's just absurd. Think about this. The points that Bill Hinman made, again, it's set. The SEC agrees. The judge agrees. It is just Billy Hinman's personal opinion. Any sort of communication from anyone else, the other side of it, the SEC is now claiming that's not personal opinion, that's super duper top secret deliberative communication within the SEC. But the other side of that communication, like the output of with the Bill Hinman free, like that part's just opinion. The other side of the equation, that's just the opinion. But if you look at the the rest of the stuff that hasn't been made public, any of that stuff, that's now super duper top secret and must remain so forever. How the hell does that make any damn sense? It's like, imagine there's two participants in the conversation, and you can only see what one of the two says. Like, that's kind of what they're trying to argue here, right? Isn't that stupid as hell? Is the judge gonna buy this? I would hope not. So now into the main thread, though, from attorney John Deaton. The worst thread I've ever written, I'm sorry. One question I get asked every time I'm on a podcast or being interviewed is to provide an estimate of how long the SEC versus Ripple case will take to resolve either by settlement or by judgment. If you've watched those interviews, you know I placed a lot of emphasis on the judge's DPP ruling. So that's the deliberative process, of course, right there, where the SEC's claiming privilege. John continues. I said if the judge pierced the deliberative process privilege and ordered the SEC internal documents produced, we could see a settlement within 90 days thereof. I also said, if the judge rules the documents don't have to be produced to Ripple, I believe the case will go to summary judgment, and possibly a jury verdict. The judge gave a mixed ruling. The SEC's big victory is that most of the documents do not have to be produced. The judge gave Ripple two victories. Number one, she ruled the emails with Hinman's draft speech are not privileged and must be turned over. And, number two, notes taken by SEC lawyers regarding meetings with third parties not associated with Ripple, i.e. Consensus, Joseph Lubin, etc., must be produced. Finally, the judge noted that the SEC could redact notes from SEC attorneys if those notes reflected the mental impressions of SEC attorneys. In short, notes reflecting exactly what the Ether investors said during these meetings, Ripple will get to read. As I said to Eleanor Terrett and Charles Gasparino on their Crypto Friday Twitter live feed, if the emails and notes contain exculpatory evidence for Ripple or damning evidence against the SEC, it could lead to a settlement. But until the SEC is forced to turn them over, it won't. Today's decision on allowing the SEC to file a motion to reconsider is terrible news related to the timing issue. Without question, today's decision will cause more delay. And so just to make sure everybody's caught up to speed, not only did the judge find that, the bill and everything that Attorney John Deaton just said, not only did she find all of that regarding all of the privilege stuff here, the SEC then came back and said, okay, but reconsider some of this here, because we want to submit more documents. And so you might be sitting there thinking, okay, well, you've had these documents for years at this point, right? Why didn't you just submit them before? What the hell is going on? Why do you feel that you deserve a do-over? And the judge listened to this, and I made a video on this in great detail. The judge looked at the SEC's official request, asking for these points to be reconsidered, and said, okay. So who knows? This could end up going worse for Ripple in theory. Really grinds my gears, folks. John continues. I hate to be the bearer of bad news. And again, did I read that part? I think I did. Without question, today's decision will cause more delay. I think I read that. If I didn't, then there you go. So there you go. And then John continues. I hate to be the bearer of bad news, but I promised to always give my honest assessment, good or bad. Here's how it's likely to play out. The motion papers will all be served on February 25th. It is fair to assume the judge will likely take 1 to 2 weeks to issue a ruling. That brings us to mid-March. The losing side then has 14 days to file objections before Judge Torres. There is no doubt whoever loses will appeal to Judge Torres. Before all the paperwork is filed related to the objections, it will, at best, be mid-April. How long will it take for Judge Torres to rule on the objections? I don't know, but 30 days is certainly fair to assume. If she does take 30 days, it brings us to mid-May. Although expert depositions will be over on February 28th, how does Ripple finalize its summary judgment motions not knowing what these documents contain? Ripple might need to seek leave from the court for an expert to supplement his/her report incorporating some of these documents. And at best, oral arguments could be at the end of May. I know. It's not like we want to hear this, but I appreciate the fact that John Deaton always has just been forthright in sharing his honest perspective, and he's just warning us here. He wrote, at best, oral arguments could be at the end of May. It's not even February yet. Oh no. feels like this thing's never going to freaking end. It's absurd. I mean, hell, I don't have a legal background, but I knew that it's not uncommon. I always know that it's not uncommon for law, the judicial system, to move at a rather slow pace. And witnessing it here in real time, I've never followed any court case so closely, but here of experiencing it in real time. Not so fun, but it is what it is. Anyway, John continues. But ask yourself this. If both Judge Netburn and Judge Torres rule the Hinman emails with the draft speech must be turned over to Ripple, will the SEC finally agree? Or will the SEC attempt to file an I had that wording down before, interlocutory appeal. Interlocutory? I think I'm saying that right. Interlocutory, appeal. I swear I had that down before I hit record. Or will the SEC attempt to file an interlocutory appeal to the Second Circuit Court of Appeals? FYI, interlocutory appeals for matters related to discovery motions are generally not allowed. But will that stop the SEC from attempting it, thus causing another 30 to 60 day delay? Believe it or not, the SEC could attempt to file a writ of mandamus before the Second Circuit. I've said from day one this lawsuit was used as a weapon. I've said from the beginning this case was never and is not about enforcing securities laws. Remember when we received the SEC's objection to my writ of mandamus? Do you remember what it said? And folks, this is one of the things that I was referencing at the outset of the video, having to do with the SEC and whether it can or cannot declare with any sort of legal oomph that something is or is not a security. Take a look at this. John Deaton shares this legal document, and so here's what they actually said. Thus, the Commission's enforcement proceeding in the Southern District of New York, brought under the Securities Act, supplies the exclusive method for testing the validity of the Commission's complaint against Ripple. And so John sums it up in the following tweet. You know what that means. He wrote, in other words, the judges and the court will test the validity of the SEC's claim that XRP is a security. In short, the SEC has admitted in a legal pleading filed against our writ of mandamus that it does not decide what is or isn't a security. Simply incredible. And folks, that is absolutely true. I mean, here's the document. Make it full screen. Again, this is what the SEC wrote. Thus, the Commission's enforcement proceeding in the Southern District of New York, brought under the Securities Act, supplies the exclusive method for testing the validity of the Commission's complaint against Ripple. What's the complaint? It's the legal filing in which they do claim that XRP itself is a security. The wording is sufficiently in there. They go. I mean, I've covered. I don't even need to speak that any further in this video, right? Like I've highlighted that umpteen quadrillion times on this channel. So what's the complaint? The complaint is that legal filing against Ripple. So how do you determine the validity of the claims that the SEC made within that complaint? You go to court. They're saying, so the SEC effectively is stating what John's saying here, which is astonishing to me because I hadn't seen it pointed out quite like this before, but it's true. Again, as John wrote, in other words, the judges in the court will test the validity of the SEC's claims that XRP is a security. The SEC is admitting, this in this legal document here, that they don't get to do that. The court must decide. There you go. They're just making the claim. The SEC is making the claim XRP is a security. The court decides whether or not it is or is not. Freaking astonishing, folks. And then John continues. If this case was truly about testing the validity, then the SEC would honor the judge's rulings, submit the evidence before the court, and have the court test the validity. More delays don't test the validity of the allegations. More delays cause maximum damage and hurts Ripple. I submit to the court and the world, delays hurt XRP holders more, but that seems to be lost on everyone except us. What's worse than anything is that there's a settlement to be made that benefits all parties, the SEC, Ripple, XRP holders, and even you, Gary Gensler. And he did tag Gary Gensler there. I do like that. John Deaton, he's not shy about tagging those people that he's talking about very publicly, and I appreciate that. So there you go. Like the true cost, that's what I was saying at the outset, like the true cost of all of this, it's rather staggering. And there's so many people that are going through this. There are people that have their actual money locked up In some instances, some people literally in the United States can't move it. It's locked up in specific funds that as a result of litigation, are just literally locked. And I've been highlighting that as well. And John Deaton talks about it fairly frequently. It's just repulsive. Like the actual cost of all of this is staggering and gigantic. So I just look forward to the day. One day we're just going to wake up and hopefully just see that there's settlement. That's what I'm hoping for. But man, it's not going to be ending in all likelihood anytime soon. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.